21 CR 050378. Good morning, everyone.
Good morning, Your Honor. David Chesnoff, Richard Schoenfeld, appearing with Mr. Ruggs. Both Mr. Schoenfeld and I have some things we want to say on the record, but we're here.
Okay, morning, everyone.
Good morning, Your Honor. Eric Bauman from the state.
All right. What would you like to say?
Okay, I'll start with Richard and I'll finish.
Okay.
So, Your Honor, when we appeared in front of Judge Bonaventure last week, we had requested that the preliminary hearing be set. We were surprised that Judge Bonaventure ultimately disqualified himself. We expressly reserved our rights and remedies as it related to that disqualification because we did not receive notice. After having done the research, we don't believe that the record as it exists is sufficient for disqualification. Judge Bonaventure cited Nevada Judicial Canons 2.11 subsection 5 as the basis for disqualification. There's two parts to that canon that would result in disqualification only if both parts are met. One is that the extrajudicial statement is made during a campaign cycle or re-election cycle, which is what Judge Bonaventure based the disqualification on. However, in order for the disqualification to actually have to occur, the judge has to commit or appear to commit to reach a particular result in the case. No such representations were made, nor are there any findings in the record as it relates to that aspect of the judicial canon. Therefore, it does not meet the basis for disqualification. Less than a year ago, the Nevada Supreme Court entered a decision in Panarelli versus District Court, which is found at 138 Nevada Advanced Opinion 12, where the court stated that a judge has a general duty to sit unless a judicial canon, statute, or rule requires the judge's disqualification. And as stated in this instance, the representations or the record as it exists does not meet the elements of the judicial canon requiring disqualification, and therefore there's a presumption that the court should sit on this case. As a result, we are requesting that this matter be transferred back to Judge Bonaventure to either rescind the disqualification order or enter findings in the record that would actually result in the necessity for disqualification under the judicial canon section 2.11 subsection 5.
And I would like to add the following. We were completely blindsided by Judge Bonaventure's pronouncement, especially in light of the fact that the District Attorney's Office Civil Division, on behalf of Justice Court, agreed to it being assigned to him. There was a stipulation filed with Judge Schwartz. Judge Schwartz ordered it be returned to him. The interesting thing is that Judge Bonaventure said on the record that he had spoken to the Chief Judge, Judge Cruz, prior to announcing that he was recusing himself. Judge Cruz was aware of the decision to stipulate to have it returned to him. So the failure on the part of either the DA's office or the Justice Court to give us notice before we walked into court, especially in light of the fact that Judge Bonaventure said he spoke to her about it before he made the decision, leaves us in a quandary trying to figure out how it is that the Justice Court agreed that it would go to him, found out it wasn't going to go to him, after agreeing to have it go to him, and then did nothing to notify us, give Mr. Ruggs the due process that he's entitled to. All it does is exacerbate the original problem, which ultimately we were successful in overturning and getting it sent to him. And so we want to have that in the record. Perhaps Judge Bonaventure can address that as well, if in fact Your Honor most respectfully returns it for him to make a full record. Mr. Ruggs deserves it. All people who come to court in Las Vegas deserve to have the kind of protections that the Constitution gives them for due process and equal protection. We believe that what's happened so far has been pretty much an egregious abuse of that. We want to give the court an opportunity to perfect the record.
Does the state have any position on this?
It's the first time this issue has come to my attention. I wasn't aware that counsel was going to present this at this time. I don't take a position on it. However, I reserve the right to change that. I would like to briefly make a record based on some of the defense counsel's comments. I can assure the court that this deputy district attorney had no idea what was going to happen when we were in front of Judge Bonaventure last week, and I was just as shocked and surprised as defense counsel was. Immediately after that hearing, I consulted with Mr. Wilson, Mr. Gaskus, and Mr. Lally, who are as you know, the administrative team in our office, they were equally surprised. So I would just like the record to be clear that none of us were aware of what was going to happen. There was no attempt to hide the ball or no attempt at subterfuge. We were simply just as surprised as counsel.
And for the record, Your Honor, we have no quarrel with the fact that they were surprised. But part of the problem is the district attorney has lawyers that work for the same district attorney's office, although they're a civil division, and they were involved. I don't know, I don't know that even Judge Cruz or Judge Bonaventure consulted with them. This is not a reflection on our colleague here or any of his bosses. It's a reflection on what's gone wrong with the system as it applies to Mr. Ruggs in the court system.
Okay. So procedurally speaking, I'm not sure if the appropriate procedure is to send it back to Judge Bonaventure and have him make the record, or to keep it here and consult with our chief and find out procedurally what the appropriate mechanism is. Because as it stands right now, it's been transferred to me. There's been a recusal. I understand that your qualms are with the method of the recusal and the record that was made with the recusal. As it stands right now, it's been assigned to me, and I need to keep it here until I work out those procedural issues on the back end and find out if we need to transfer it there, or if it's just a matter of him actually filing an order in the case to make the appropriate record. So I think from here what we should probably do is follow the district court's order, set the preliminary hearing within 60 days as they've requested, have that on the books at least so that we can start moving this case forward. And then if we need to work out those procedural issues or get an order filed or whatever it is that needs to take place from there, we can do that in the interim. And if at some point it needs to be transferred back to Justice Court Department 9, based on your objections to the transfer to this department, then we'll go ahead and do that.
I have one request again, Your Honor.
Yes.
Mr. Baumann and Mr. Schoenfeld and I be present when there are discussions.
Absolutely.
Thank
Yeah,
you.
absolutely. We'll make sure that everything is taken care of openly and that we're all part of the conversation.
I appreciate that.
Okay, so the 60 days that we've looked at, so we have to start kind of playing around with the calendar, is April 26th and 27th, is that right?
Or we could actually, when we were contemplating setting a preliminary hearing in front of Judge Bonaventure, agreed upon May 4th, if the court has that available
Okay,
to
let
work
me
for all of our
just check.
schedules.
May 4th is a Thursday, and that already works for everybody here?
Yes.
Okay, May 4th at 9:30. How's it looking for us? Okay, so we'll close out whatever else we have that date. So May 4th at 9:30, after this hearing, we'll be in contact with everybody, that way we can all have a conversation.
Your Honor, one other request.
Yes.
As a result of receiving discovery after we had previously discussed the legal issues surrounding the taking of the board, we received materials from the DA's office that Metro had not given us. In the course of reviewing that, we now believe that there is additional information that the court should hear. So we would like to do the motion that we're going to file on the same day, and we would ask you to set a briefing schedule for us so that we can get a briefing to you, and the state has plenty of time to reply.
Okay, and so it's going to be a motion to reconsider,
It's going to be a renewed motion to suppress the blood test evidence.
renewed, okay. All right, so how long do you need to file that renewed motion to suppress?
2 weeks, please, Your Honor.
Okay, so 2 weeks puts us, file so big I can't see the calendar. Okay, so the renewed motion to suppress, March 13th, how long does the state need to file an opposition?
I typically ask for 30 days, but I see we're on somewhat of a compressed schedule, so I'd submit it to the court.
Okay. Let's go 3 weeks for the opposition.
And we'll take a week to reply if you would,
Okay,
Your Honor.
so 3 weeks for the opposition puts us at April 3rd. And then 1 week to reply puts us at April 10th for argument on May 4th as well, right?
That's
Okay, and if everybody could please provide a courtesy copy to Chambers, that way I have everything.
Right, and I
Okay.
will also wait to hear from you about the discussions about the next procedure.
Sure, as soon as I can get through the calendar, I'll be in touch.
Okay.
Okay,
Thank you, Your Honor.
thank you all.
Nice to see you. Your
Thank
Honor.
you. File this way. Okay.